Good morning, everyone, and thank you for joining this web seminar. It's one of a series that we're offering to help businesses through the coronavirus pandemic. Firstly, a little bit about Blaser Mills and me. There we go. There we go. So firstly, a little bit about Blaser Mills and me. Blaser Mills is a Buckinghamshire-based law firm. We've got an office in High Wycombe and also one in Amersham and an office in central London. And we help both individuals and businesses with their legal needs. And we're very pleased to be working with BBF and Buckinghamshire businesses generally on their legal requirements. I'm a partner in Blaser Mills, and I specialise in employment law and also data protection. That's a mugshot of me, not a very good picture. And I've got about 20 years experience in dealing with those specific areas. I'm also a non-exec director for a local technology company in the agricultural sector. So, well, firstly, the phrase furlough, I don't think many people were aware of the phrase until about the 20th of March this month. Now you can see it everywhere. But in fact, it's a phrase which I think has been taken from the Americans. The Americans are quite used to the phrase furloughing and furloughing of staff. And I think the government have chosen it in order to differentiate between some existing provisions that predate the furlough scheme and go back to our industrial days of the 1970s, because there's always been a right to furloughs or lay off staff or to put them on short-term working. But the balance within the provisions enabled employees to effectively trigger a redundancy if they were laid off for a particular period of time. And of course, that would defeat really the object of the scheme, which is about job protection, but also to help businesses with cash flow. And so what the scheme is trying to do is it's trying to help employers provide job security for employees who are affected by the COVID-19 pandemic. And it's important, it's not clear yet how much due diligence HMRC are going to do in regard to that. So are they going to check whether in fact an employee is at risk of redundancy because of the pandemic or for other reasons? But certainly it's useful for employers to have some information to support the decision to furlough staff for that particular reason. And broadly, what the scheme will do is it will pay up to 80% of the wage costs for an employee up to a total of £2,500 per month. And the scheme will backdate to the 1st of March, providing certain conditions are met. And it's anticipated to run for 3 months to the end of May. It could well be extended. We'll have to see how things develop. But at the moment, it's slated to end at the end of May. And the application for the scheme will largely depend upon when staff were placed on furlough leave rather than just automatically applying from the 1st of March. So who can claim under the scheme? Well, the scheme's pretty broad, actually. It applies to most businesses and organisations, so charities, recruitment agencies and public authorities can access the scheme. But there are some conditions that apply. Firstly, the organisation needs to have a payroll scheme on or around which was in place before the 28th of February this year. That's a crucial date for a number of reasons. In addition, the organisation needs to be enrolled for online PAYE, and if you're not, you can still do that. There's a process of about 10 days, I understand, from HMRC to do that. And also, the organisation needs to have a UK bank account because that will be the bank account that's receiving the grant. There was some guidance issued over the weekend because the rules were issued on the 20th of March, and there's been the detail of it's been coming out in bits and pieces. And there was a significant upgrade over the weekend, and that confirmed that actually the scheme is also available to individuals who employ people. So individuals who may have a nanny or a gardener, provided they operate PAYE, they can access the scheme. And also, as a nod to where things may be going in the economy, the government also confirmed that administrators of companies, so who take over the administration of a company that's looking like it's insolvent or about to go insolvent, they can also access the scheme to protect jobs, provided that the administrators are going to be running the business for the purposes of a sale or to keep it alive rather than just to liquidate it. So what is a furloughed worker? Well, the furlough scheme is effectively a temporary cessation of work, or a temporary sort of suspension of work. And as I said earlier on, it applies to employees who've been asked to stop work for at least a minimum of 3 weeks because of the pandemic, either because there is no work for them to do or because the employer cannot pay their wages. And as it's merely a sort of a temporary suspension, the employee's normal contractual and statutory rights will continue, save as varied by the scheme, which is the suspension of their work. So they will still benefit from rights such as statutory maternity, sick pay provisions as varied for the pandemic, and also unfair dismissal rights. And the scheme is going to be run by or managed by HMRC, and they're going to want to see some various factors in order to clarify the status. And one is that there needs to be a formal change in status from employee to a furloughed worker. And they'll expect to see something in writing to that effect. And they're expecting employers to keep a record of that for at least 5 years. Now, the government has also made it very clear that when you're changing status from normal employee to furloughed worker, you have to comply with employment law and normal employment contractual provisions. Now that can pose some problems because particularly 3 particular areas. Because firstly, if you're going to be furloughing staff, you are going to be potentially selecting staff for that status. Now, it may be slightly easier when you're doing an entire team, but when you're selecting individuals from a team, there will be questions raised as to why you're selecting particular employees. And so whilst you don't think you need to go through a full redundancy selection process, you do need to show that you've got some objectively fair reasons for why you're selecting a particular employee and to record that decision. The second issue is that placing somebody onto furlough means you're effectively changing their terms and conditions of employment. And there are 2 bits to that. One is the suspension or the change in status. And the second is the fact that you may be changing pay, because obviously under the furlough scheme, you can reduce to 80% of wages to that 2,500 cap. And both of those will be changes to terms and conditions of employment. Now, most employers have the right to suspend staff, so changing status should be relatively simple, but making a change to the pay is more substantial. And unless you can get the employee's agreement, you're going to be having to look at how you make that change or impose that change. Now, some employment contracts do have a right already built into them to allow the employer to make that change. Sometimes it will be a right of variation. The clause sometimes appears towards the end of the employment contract, but the courts don't like employers relying upon broadly drafted variation provisions to amend or to change pay. Therefore, if you can't get agreement from staff to make these changes, then it raises the prospect of having to go through a formal process to make the change, and that will require potentially consultation. And where more than 20 staff are at risk, then the collective consultation obligations can kick in. Could I just ask, I think someone's on loudspeaker and there's a bit of noise coming back. If you could just mute, that would be really appreciated. Thanks. Collective consultation arises where more than 20 staff are at risk of being dismissed within a period of time at a particular establishment. And that can apply in a change to terms and conditions situation, because the textbook way of making a change is to consult with staff to get agreement. But if you can't get agreement, you then terminate the existing contract and offer the revised contract on expiry of the old one. And that involves a dismissal. And therefore, that's why these collective consultation rules may well apply. It's the dismissal of the existing contract or termination triggers that consultation obligation. Now, the risk is that if you don't go through that consultation, firstly, there is a standalone claim for a failure to consult of up to 90 days pay per employee. But equally, any employee with more than 2 years service also has unfair dismissal rights, and a failure to consult before dismissal can result in an unfair dismissal claim. So you have to be very careful about consultation rules, and particularly these collective consultation rules, because it could expose you to risk of both a consultation claim and potentially an unfair dismissal claim. Now, the way to sort of potentially avoid that is to see whether you can disaggregate the numbers, so you have less than 20 at an establishment. An establishment, for the purposes of the collective consultation, is a particular location which has autonomous management system, or just bring the level of staff down below that 20 level. Just moving on. So, which employees can be furloughed? I mentioned earlier on that there's a key date, which is the 28th of February. Basically, you have to be, an employee has to be on the payroll system at the 28th of February, and it applies to both full-time staff, part-time staff, agency workers, including those who are employed and working via some form of intermediary, possibly an umbrella. Again, I stress, provided they're paying payroll via one of the intermediaries. It applies to flexible workers, also zero-hour contracts. And the guidance that the government issued over the weekend also confirmed that it extends to a broader range of individuals. So it also applies to apprentices on apprenticeship contracts. And what the government has said there is that you can still train apprentices who are on furlough. You just have to bear in mind that when they're on days of training, that the wage they're paying, that you're paying them when you're applying the 80%, if you're not topping up, is above national minimum wage for the training time. The scheme also applies to employees who are shielding, so who are off work because of COVID-related reason, they can be furloughed. It also applies to employees who are not working because they've got caring responsibilities, possibly looking after parents or children. It also applies to fixed term contracts, and if a fixed term contract ends part way through the furlough scheme, an employer can extend the fixed term if they wish and still stay within the furlough scheme. Interestingly, and part of the protection for the sort of non-employee group, so self-employed, the government obviously was moving to try and protect that category of worker. The guidance over the weekend is issued that some non-employed individuals can also be covered by the scheme. So that particularly covers office holders who may also be LLP members of professional practices like myself, company directors, and that includes company directors of companies where it's a sole director, and also workers known as Limb B workers. So Limb B workers are the category of worker that sits between employees and the self-employed. So they don't have full employment rights, but they're not completely self-employed. And provided that all of these office holders, company directors or workers are on the payroll system and paying tax through PAYE, they will be able to access the scheme. Now, what that poses difficulties in relation to sole directors of their own company, because under the furlough scheme, you're not supposed to do any work for your employer. And what the government has clarified is that for directors, you have to differentiate between statutory duties as a director and the work you do for your company in terms of raising revenue or income. And the government has clarified that provided that you're only doing the statutory duties, you will not fall foul of the furlough rules, so you can still qualify for the furlough grant. Just some specific points. The scheme does apply to staff who pre-20th March had been made redundant. So as long as they're rehired and put on furlough leave, as long as they're on the payroll as at the 28th of February, they can be furloughed, and the payments can be backdated. The payments are actually backdated to when an employee stops working, not necessarily when the agreement to the change in status occurs. The key point again is that the staff needed to be on the payroll as at the 28th of February. So anyone who, unfortunately, who was recruited or joined the payroll after that date won't be caught. Furlough will not also apply if employers have been quick off the mark and have already implemented some other form of layoff or reduced hours or reduced pay. So if you've moved to reducing pay for staff before the scheme was introduced, unfortunately, the scheme will not apply to you. It also won't apply to employees who are self-isolating or sick. The sick pay rules will kick in those circumstances. For employees on maternity leave and other form of parental leave, again, this was a slightly grey area, but it's been clarified a little bit more by the government. Effectively, because they're already on a form of statutory suspension, that statutory suspension will continue, and you can't convert over to furlough leave unless somebody returns, exercises their right to return, and can return before the end of the statutory period. It will, however, and it's going to be interesting to see how this works, apply to if you enhance pay. So if you pay enhanced maternity pay, the furlough scheme can apply to those enhanced payments. I think there'll be hopefully some more detail issued as to how that works. One grey area still is what happens with holidays and holiday pay. It's not, some commentators think that holiday may not continue to accrue during the furlough period, or employees are entitled to take pay or be paid for holiday. My personal view is that because it's only a suspension from work, when you're placed on the furlough scheme, all your other terms and conditions continue to apply. My view is that holiday will continue to accrue. There's a question as to when, if staff want to take holiday during the furlough period, what they're paid for those days. Under the holiday pay arrangements as they were, there is an argument to say that it should be at the full rate, at the 100% rate. And I know some employers are using this as a facility to help staff top up pay if they want to by using holiday in return. It's also technically possible for employers to force staff to take holiday, generally, not just within the furlough scheme. And you can do that by giving twice as much notice as the holiday you want them to take. So if you want someone to take 5 days, you need to give 10 days notice, working days notice. There's a question about whether forcing staff to take holiday on furlough, because if it's continuing to accrue, you'll have that liability at some stage. There's a question whether that's reasonable or fair. We'll have to find out how that comes about, because of course if you're furloughed you can't really take holiday. But if the reasoning is because people want to top up pay, then that would seem to be a reasonable approach. So how does the grant work in terms of the amounts? So as I was saying earlier on, it's effectively 80% of salary to a cap of £2,500 per month, and the 2,500 is applied after the 80% is applied, and you can top up as an employer, as long as you pay the 80%, you're within the scheme. You can top up to the 100% if you want. The calculation is based on basic salary as of the 28th of February, that key date again. And over the weekend, because there was some discussion about what for staff who had potentially significant payments under commission or bonus schemes, the government clarified that the calculation also covers regular guaranteed payments, so including fixed commission or bonus, so it's fixed commission or bonus, that will form part of the calculation. The scheme will also cover the employer's national insurance and the statutory auto-enrolment pension contributions up to the 80%, because if you're paying 80%, it will be 80% recovery of those elements. And that's in addition to the 2,500. And there was some question about if the 80% took somebody below the national minimum wage, what did that mean? Well, the government have confirmed that if you're furloughed, you're technically not working, and therefore you don't qualify for national minimum wage for those hours, and therefore an employer can effectively take the wage below national minimum wage for the furlough period. Where pay varies, so for those, for example, working on an hourly basis or 0-hour contracts, you look to an average. Basically, it's the highest of the equivalent pay for the same month in the previous year, or you take an average calculation over the 2018-2019 year, and as I say, take the higher of those two. If someone's had less than 12 months, so you don't have that period to do the calculation, you just use the average monthly in the time that they've been employed. The scheme is very clear that it will not include discretionary commission, bonuses or other supplements. So a lot of contracts have discretionary bonuses rather than fixed. They'll not fall within the scope of the scheme. It also will not cover benefits in kind, so car allowances or other benefits that are provided, and it will apply on if a company operates salary sacrifice in relation to benefits, it applies on the post-sacrificed wage, although the government has indicated that a lot of sacrifice schemes allow staff to opt back in if there are what are called life events, and the government will regard this as a life event. So that gives theoretically a possibility of someone being able to opt back in to a scheme to recover their sacrifice salary and have the furloughed rate applied at the higher rate. The calculation also doesn't cover the apprenticeship levy or student loans. They will continue, they're not suspended, so the grant will not cover that. And as I said earlier, employers can, but don't have to top up to the 100%. It's an important condition of the furlough scheme that staff who are furloughed must cease work for at least 3 weeks, and they cannot take up other employment with the same employer. They can work, so those who've already got dual employment, so working for another employer, the fact that they're working for another employer will not disqualify them from a specific furlough scheme operated by the other employer. So it's theoretically possible that someone could be furloughed from 2 employments. Employees can undertake volunteer work, and they can do training. And again, there's a question about if someone's training, what their pay is going to be for any hours that they do. It may be that you've got to top up to the 100%. Theoretically, an employee can also do volunteer work for their employer, provided that it doesn't make any money or involve any provision of services to the company. And I would just recommend that, because it's going to be very unclear what that means, I would make sure that the only thing you do with your staff, if you want to keep them within the scheme, is possibly to look at training and not any other form of work, and obviously keep a record just in case HMRC interrogates the matter. And as I say, employees can work for other employers during a furlough scheme, bearing in mind that employees still remain under their normal terms and conditions of employment. Technically, an employer can have a say over whether someone works during normal working hours for somebody else. You may have a concern, for example, if they're looking to work with a competitor, and therefore it would be reasonable to ask staff to say that if they are going to work for someone else, that they tell you, and where appropriate, get your consent before they do so. And then just in terms of the reclaim process and the payment process, The 80% calculation, or the cap at 2,500, is a gross amount, so you still have to apply PAYE on that, although you will get a reclaim of the employer national insurance and the auto enrolment pension contribution. Once you have designated staff as being furloughed, you'll need to submit details through a new online portal system which is being set up by HMRC. They said they don't have the systems to manage this yet, and they hope the system will be up and running by the end of April. And the guidance suggests that rather than submitting a claim for the full 100% and allowing HMRC to do the calculation, you'll effectively do the calculation for them and make the submission based at the rates or the cap. And HMRC have indicated the sort of information they will need through the portal. So PAYE reference number, that's because, as I said earlier on, most of this really only applies to someone who's on an existing payroll or paying PAYE. The number of staff being furloughed, the claim period at the start and end date, start date being the date when the employee stopped working for you, the amount claimed, bank account, and contact name and telephone numbers. Now, just one further point on furloughing, going back to the earlier slide. Staff, it's a little grey, but we think that employers will be able to place someone on furlough, and to qualify for furlough, it needs to be a minimum of 3 weeks. But then you might be able to bring someone back and put someone different onto furlough, provided again they're for a minimum of 3 weeks. And then after 3 weeks, put the original staff back on furlough. So there seems to be some suggestion that you can rotate staff under the furlough scheme, provided that they meet the other criteria, and that includes being on furlough for a minimum of 3 weeks. I think that covers everything so far, so I'm very happy to deal with any questions and answers, or questions that anyone has about how the scheme operates. If you want to submit your answers through the meeting chat, or if you want to go onto the audio, I'm very happy to answer questions either way.
Hi James, it's Becky Salisbury here.
Hello.
We've got an echo. Okay.
I can just about hear you.
Right, I'm going to off and on again. Hold on. Hi.
Hello.
Yeah. I run a couple of pubs, so I've had to furlough everybody. So I've got a couple of questions. First one is no mention of tips.
Tips are outside the calculation.
Okay, I thought they might, but it's just never mentioned. It's always strange when there's over 3 million hospitality workers, it's not mentioned. Now, just to be, and on that final thing, you said it said that all the details that you had to give of your employees for the scheme, and it said their bank account. So just can you clarify where the money will be repaid to?
I think actually that's a typo. It should be, I think the employer will have to have a UK bank account and will provide their bank account for the payment of the money, and then the employer has to pay the employee.
Okay, just wanted to confirm there. That's lovely. Thank you.
If you look at the coronavirus job guidance on the government website, which gets updated quite frequently, it's got information, and that's where you'll see that it confirms that tips will not fall within the scope of the calculation.
Lovely, thank you.
Got some questions coming up in the chat. So agents, it's not clear whether agents can claim for furlough. I'm not sure whether that means agency workers or commercial agents. Commercial agents is a category of it's like a self-employed salesperson, effectively, who've got commercial rights. They wouldn't qualify for the furlough scheme. Agencies, those working through agencies, if they're paying, if the agency is paying payroll for them, those individuals are most likely to be regarded as Limb B workers and therefore covered. If not covered because self-employed or the way in which they work, then there is the self-employed scheme which they might be able to access. Got a question about, can the whole workforce and directors be furloughed at one time? Interesting one. Theoretically, if the business is effectively going into lockdown and that's the only way it will survive the pandemic, then theoretically I think that's possible. Again, directors would need to be on the payroll for the company but on or before the 28th of February. But theoretically, I can see it's possible that the company is effectively put on ice with everyone being furloughed pending the pandemic ending. This question about dividends. Dividends are not, there's a bit of a grey area, but they're not included. I think it might depend upon the dividend policy because it goes back to whether it's a fixed payment. But I suspect that HMRC are not going to allow dividends to form part of the calculation. Then I've got a question about notice periods before staff can be furloughed. There isn't specified in the scheme a specific notice period that has to be given. It's just about confirming that someone's changed status, and the ideal is to get the employee's agreement to that, failing which is to go back to the point about changing terms and conditions, question about whether you can impose the change in status. I think there may well be some litigation in the future about some of these issues. We'll have to see how that comes out, but I suspect that imposing a furlough status on an employee, provided you've got objective reasons for doing so, will not be regarded as being a breach of contract or unfair. The change in pay is the second issue, which I mentioned about how you reduce pay if you don't have an express right, and I think that's where there's going to be more prospect of disputes where staff object to the change and how employers go around imposing that change. Question about what we need to do to ensure that you can backdate claims. I think, again, this is a sort of an unclear area, but you're going to have to evidence that staff stopped working for reasons connected to the pandemic on a specific date. Now, I think through the portal, you'll effectively confirm the date to revenue, and you'll maybe asked to declare or sign a declaration to that effect. But if it is interrogated by HMRC, you'll need to be able to point to some evidence to suggest that you asked the staff to stop working on a specific date in order to justify the claim. Question about local community centre. Are there any implications of furlough staff and standard employment law? Well, the scheme is slated to run until the end of May this year, could well be extended. Standard employment law, again, as said earlier on, it's about how you select people and how you make the change if you are going to drop the pay to the 80% or £2,500 cap, how you go about doing that in accordance with either the contract or consultation obligations. So you just need to and also look at the numbers of staff who are being affected, because if you're plus 20, then you may engage the collective consultation obligations. I think there's a question about if staff have been furloughed from the 20th of March. Not quite sure if I understand the question from Jules about catching up beyond returning to work. Maybe it would be helpful if you could just sort of clarify that question. Going back to an earlier question about agents. Question about who effectively fills in the details for the claim, whether it's the accountant who handles. We'll have to see what the portal requires. It's not yet live. I suspect we'll understand more when the system goes live about who has to do the inputting and sign the declaration, but I would imagine it's going to be very much like a payroll function. It's a question about pay rises, where there was a pay rise due from the 1st of April, and how is this handled for furloughed staff? I think there are 2 points. Firstly, whether the pay rise is sort of hardwired, whether you can exercise a discretion not to pay rise. But if you want to pay rise and you do pay rise, the scheme suggests it's the salary as at 28th February, which will be the one that HMRC will use for the benchmark, and therefore you'll have to be operating off that number, not the increase from the 1st of April, which means unfortunately the staff potentially will lose out unless you top up for the remaining balance. It's a question about employment contract with base salary and fixed commission. Would it be the 80% of the basic or the average over the last 12 months? The scheme will cover fixed payments. So if the commission is varied over the past 12 months, I query whether in fact it's genuinely a fixed payment, because fixed payments would obviously be normally at a set rate. I think that's really going to be quite fact sensitive as to how your contract is drafted, what it says about fixed commission, and ultimately the scheme rules out how HMRC interpret them. But if you're paying a fixed amount on a monthly basis, revenue are going to be working off the 28th of February, so it will be the figure, I think, for that month. Where it's potentially variable, it could be the variation rules where you look at the highest from the same period last year, or the average 12 months for the last tax year, if they've been employed for more than, or if they've been employed during that year. So a question about company had had imposed a 20% pay cut, and staff have now been furloughed from the 1st of April. The way the guidance works suggests that, unfortunately, if you've already imposed some form of reduced hours or reduced pay, the furlough scheme will not apply. Again, that might be quite fact sensitive, and also have to see how the scheme rolls out more generally. But the guidance suggests at the moment, if you've already imposed some form of reduced hours or pay cut, you can't furlough or get the benefit of the furlough scheme. So a question around staff being furloughed from the 20th of March. I think the question around furlough periods and claiming, I think the way it works is that, and it'd be interesting to see how the portal eventually comes out that HMRC are going to be used, I think you will just submit details of your claim and the amount per employee. And so if you furloughed somebody for a 3-week period but brought them back, they'll be included in the overall claim, and you'll just get the grant based upon the prorated period of the 3 months which they were furloughed. I hope that answers your question. Question about minimum wage rises from the 1st of April. Yes, that would obviously go through, but as I mentioned earlier on, because staff who are furloughed technically aren't working, minimum wage would not apply, so the calculation can take them below the new minimum wage from 1st of April. Question about pay rise from the 1st of March. Whether that will be the pay for the purposes of the 80% or the pay on the 28th. I say the revenue again has indicated that they'll be taking the pay as it is on the 28th of February. I think that is because they want to avoid a situation where employers just hike wages in response to the furlough scheme to claim a higher amount. So it will be benchmarked off the 28th of Feb. Question about if someone's joined on the 28th of Feb, just on the border. Interesting to see what HMRC will say about that. It seems to me that if they're technically employed on the 28th and were on the payroll system at that point, they should be covered. It may be that there needs to be a tussle with the revenue to persuade them to include that person. Question about someone who's self-isolated, whether they can be furloughed. Just going to double check the guidance on this, because I think unfortunately they can't. So the guidance says if your employee is self-isolating or on sick leave, they'll be able to get sick pay. You cannot claim for employees while they're getting statutory sick pay, but they can be furloughed and claimed for once they are no longer receiving statutory sick pay. I hope that answers the question. Question about how did the claim work? Again, it's difficult to know until the portal's set up, but I think yes, you continue to pay and you claim it back as a grant from the government through the portal. Keith Robinson would like to ask a question. Would you like to do that verbally? Is Keith still on?
Well, it's Mrs. actually, so it's Sylvia. Hello.
Hello.
I'm in the childcare industry, which causes me some complications because I have some members of staff that are term time only workers.
Yeah.
So the way they normally work is they have their whole year's worth of pay whilst they're working. So they have to have holiday pay during the school holiday breaks. So, for example, we're furloughing them all from the 1st of April. So usually in the month of April, we have Easter. So they would normally have 1 week's worth of holiday pay and then a week where they don't get paid because obviously they're not normally working. So how would that work if we're looking at the sort of the highest salary for the month equivalent? Because obviously they're already going to have lost out in a week's. Because then when we go to May and June, those months would be different. May's not so bad because again you get a week's worth of when they're not there because it's school holidays again. But June they would work for the whole 5 weeks of June.
So just so I can be clear on it. So somebody goes on term break when?
During the 2 weeks of the Easter holidays.
2 weeks, and they're paid for a week as holiday.
Yeah, their holiday pay, because they can't take holiday during school term time. And
Okay.
We can't pay them a set rate each month, because that would bring their salary below the minimum wage over a 12-month equivalent, because obviously in the month of July and August they don't work at all.
So you technically don't pay them for 1 week of that period.
No. Said it was complicated.
Yeah.
So the way it usually works, over the whole year, they have 1 week of holiday pay during the Easter break. They receive 2 weeks of holiday pay during the summer break, and then they receive another week of holiday during the Christmas break.
So is this fixed arrangement?
Yes.
Okay. To be honest, I think it may be something that needs to be discussed with HMRC when the portal gets set up.
Okay.
But I suspect the answer will be that you will only recover 80% of what you pay during the 3-month window.
So can the furlough pay change each month?
It shouldn't do unless there's a fixed change within the say a fixed sort of bonus or commission payment that's due. But as I say, normally they're going to take it off for fixed basic salaries. They're going to take it off the 28th February payroll figure.
Right. Okay.
It's only where it's variable by way of hours or like a 0 hours contract, where they'll look back over the period last year or the average for employment.
Okay.
So yeah, unfortunately it's a bit fact sensitive, but I suspect what it's looking effectively what the system is going to do is going to give you a grant to cover the costs or a percentage of the costs for the furlough period, and those costs will be what's fixed by the contracts, or if it's not fixed, what the practice has been either last year or across the period of employment this year. So where you've got a fixed arrangement like you have, I suspect it will just be it will turn off the way the system operates. Hopefully that will help a little bit, but I think it will be definitely a question with HMRC when they roll out the system.
Okay. Another one, I had a member of staff who left me. Her last day of working was Friday the 28th of February, so she was still on payroll then. Her new job, bless her, she was supposed to fly out to Greece to work in a holiday hotel pay scheme, so that's obviously finished.
Yeah.
There was talk that I could put her back on again to my books to then furlough her.
She didn't leave you because of redundancy or because of the pandemic, did she? She left for different reasons.
No, but her new job has been cancelled due to the pandemic, and she obviously wasn't then on their payroll to be furloughed by them.
I think the answer to this question is one that probably shouldn't be put across to a public network, but I think the scheme rules as drafted would not cover it.
Okay.
Because she didn't stop working for you for reasons connected to the pandemic. It is possible where somebody has given notice to agree that a notice is withdrawn, and so someone's employment will continue. And it's also technically possible to rehire somebody. But as I say, the dominant purpose here is to protect staff who are stopping work because of the pandemic, and stopping work for that specific employer because of the pandemic.
Okay. Right. Thank you. Thank you very much.
Welcome. Just one final question. Once the grant is received and entered into the accounts as income, which will then be taxed as profit, it is going to be, again, if you look at the guidance, the government confirms how it should be treated. It will be treated as income, but you'll have the offset as the payment that you're paying to the staff as a deductible. So it should net off. I think that's all of the questions through the chat function. Does anyone else have a question? I think that's it. I think, well, thank you for listening. Thank you for all those taxing questions. I hope it's been of use, and we're available clearly offline if you have any other questions. Oh, one other question just quickly popped up. Does the employer have to pay the 80%, then claim it back? Yes, I think that's the way it works. You'll pay and then recoup through the system. So yeah, please get in contact if you have any other questions about how the system operates. And I think, as some people have already noted, there may be some more questions that come up when the portal opens and we see how the revenue are going to run the claim system.
Okay, James. That was great. I don't know if there are any more questions that are pending at all. I think that's a lot. Thank you everyone for attending today's webinar. James's details are here on the screen if you would like to make a note of them, so you can direct him if you do have any other questions that you'd like to put forward.